If you're in California and your spouse of 7 years says, "My lawyer just filed for divorce. I want you out of the home. I want to keep the kids." Here are the three most important things you must do immediately. 1. Do not leave the home without a court order. Why this matters. In California, both spouses have equal rights to remain in the marital home until a court orders otherwise, even if the home is only in one person's name. If you move out voluntarily, it may weaken your position regarding child custody, support, and property division. Leaving the home can be used against you to show lack of involvement with the children or imply abandonment. What to do? Stay calm and do not escalate any conflict. Politely but firmly state, "I have legal rights to stay here until a judge says otherwise." If things get hostile, document everything and avoid confrontation. 2. Immediately retain a family law attorney. Why this matters. The moment your spouse has an attorney, the balance of power shifts. You need equal firepower to protect your rights in future. You're now in a litigation posture, and you need to file a response, FL 120, within 30 calendar days or risk a default judgment. You'll also need to consider filing requests for orders, RFOs, for child custody, visitation, and exclusive use of the home. What to do? Hire an attorney immediately. If cost is an issue, seek help from legal aid or ask the court to order your spouse to pay your attorney's fees. Family Code Paragraph 2030. Preserve and gather financial records, text messages, and any relevant communications. 3. File an RFO for temporary custody orders. Fast why this matters. If your spouse is trying to keep the kids and you do nothing, you could lose precious time and lose de facto custody status. In California, the status quo is very persuasive to judges. If your spouse ends up with the kids for weeks or months without you challenging it, that becomes the new norm. Filing an RFO for temporary legal and physical custody orders allows you to put your foot down legally and stop unilateral action. What to do? Ask your attorney to immediately draft and file a request for order, Form FL 300, for temporary custody and visitation. Include a detailed declaration about your involvement with the kids, any threats made, and why shared custody is in the child's best interest. If there's any sign of manipulation or threats by your spouse, consider requesting a mutual restraining order. Bonus: document everything. Start a secure journal, written or digital, documenting dates and times of conversations or incidents, any attempts at being excluded from the home or kids, your ongoing role as a parent and homemaker. This becomes critical evidence in custody and property battles. Act now. The sooner we start, the stronger your defense. Give us a call at 888 888 6582